Hello, I'm Amanda Moore. I'm the Director of the Clearinghouse Community. Welcome to the Advocacy Exchange for March 2018. The Advocacy Exchange is our monthly conversation with advocates advancing change. Joining me today is Abbi Coursolle. She's here with us for the Advocacy Exchange. Both the Advocacy Exchange and the Clearinghouse Community are brought to you by the Sargent Shriver National Center on Poverty Law. It's a national leader in advancing justice and opportunity, and we're happy to have Abbi with us. She's a senior attorney at the National Health Law Program, and she's joining us today from Los Angeles, California. Hi, Abbi. How are you?
Hi, I'm fine. How are you, Amanda?
Doing well. I'm glad you're here. So Abbi is also the author of this month's Clearinghouse article. It's called Executive Directives, What Poverty Lawyers Need to Know. And you can find it at the address on my screen. It's povertylaw.org/clearinghouse. We're going to talk in detail with Abbi today about that article. But first, before we get into our conversation, I want to let you know how you can be part of it. We welcome your questions and comments as we're talking. You can submit those to us a couple of ways. One way is while you're watching through YouTube, you'll see to the right of the screen, there's a live chat box there. David in North Carolina has already said hi. I'm glad to hear from him. You too can use the live chat box and send us your questions and comments. If you want to go ahead and give it a try the way David did, please do. Let us know your name and where you're watching. If live chat is not your thing, that's okay. We'll also take emails. You can email me at the address on my screen, Amanda Moore, M-O-O-R-E, @povertylaw.org. So let us hear from you. We want to hear your questions. Everyone who registered for today's Advocacy Exchange will get a follow-up email in a couple of days. And in that email, you will find a link to a recording of today's conversation, a link to Abbi's article, as well as a link to register for next month's Advocacy Exchange. So be sure you open that message when it hits your inbox. So Abbi, let's start. And let's start with the basics. What is an executive directive?
Sure. So an executive directive is sort of an umbrella term that we're using to talk about all the different types of written actions that a president can take to implement policy. So that includes executive directives, which are probably the best known type of executive action, but also presidential proclamations, presidential memoranda, other types of administrative orders and notices and things of that nature.
So, executive orders, I think, are probably, like you said, they're the most well-known. They're the ones that are often in the news. And interestingly, when we had President Obama as our president, he caught a lot of flack for issuing executive orders to advance his policy goals. And now we have President Trump, who has issued more executive orders thus far in his term than any recent president had that far in his term. So it's interesting that people, depending on where they fall, they like executive orders when it's their guy in the White House issuing them, and they don't when it's not, which leads me to wonder, is this even a legitimate way to make law?
Sure, I think that's a great question. And I mean, the answer, like many legal questions, is it depends, right? When the early presidents issued these types of executive actions, they were often more, routine sort of things, setting up the various offices or the administration of the White House, or making sure that the agencies ran smoothly. But over time, they really have evolved into a way for presidents to implement their policy agenda, particularly when presidents aren't able to get things done through Congress, which is something that we definitely saw in the Obama administration, and I think in the current administration as well. And so the answer is they can be legitimate, but of course there are certain safeguards in place that puts some outside limits on what presidents can do through these executive actions. First and foremost, they can't violate the Constitution. The president has to have the actual authority to issue the executive action. So there are certain areas that are reserved exclusively to Congress to act, for example. And so the president can't tread on that territory through an executive action. And then they can't violate any other law that's been duly enacted by Congress. So those are the general rules about what the president can do, but that still leaves, quite a lot of discretion for the president to act.
Yes, and it's interesting because they do seem so impermanent without a lot of the procedural safeguards that we're used to having. And so I want to talk more about that as we go through our conversation. I'll remind our viewers, please let us know your questions for Abbi. You can send them through live chat on YouTube or email me here, Amanda Moore, Moore, at povertylaw.org. So thinking about ways to challenge these executive directives, since these are executive actions, they're coming from the executive branch, can they be challenged under the Administrative Procedure Act?
Generally, no. So unlike the Administrative Procedure Act, which governs the actions that agencies take, and many of you are probably very familiar with the APA, and you know that there's this whole process of rulemaking that involves notice and comment and opportunity for the public input. Sometimes there are public hearings. So there's a very sort of formalized process that agencies have to go through to put out their formal policy guidance in the form of regulations, for example. But the president is not considered an agency under the Administrative Procedures Act. And so any action that he takes is exempt, or just not subject to the APA. So it's much more of an informal process. Really, the president can just sort of write something down on a piece of paper, sign it, and make it law as long as it doesn't violate those other safeguards I discussed. Over time, there have been a few procedural safeguards put into place. So for executive orders, for example, they do have to be published in the Federal Register. They're assigned a number, so you can sort of look and see all of the ones that have been issued over time. But beyond that, the president has quite a lot of discretion to put them out without having to go through any sort of review process or invite comment. And the president also has complete discretion to revoke them or modify them at any time. So a president can put something out through an executive order, for example, and decide a month later that that wasn't quite right and either modify it or rescind it and put out a new executive order on the same topic. There's a lot of discretion there.
And executive orders that came before, right? I think in your article you talk about the Mexico City policy. I think that's a famous example.
Exactly, yes. So that's one of the most famous examples where, and the Mexico City policy, or the global gag rule, for those of you who don't know, is a policy about whether medical providers who receive certain types of foreign aid, what they're allowed to say or do with respect to abortion. And so under the Reagan administration, there were restrictions placed on these types of funds and that prohibited doctors and clinics to receive this kind of aid from providing abortions or talking about abortions. That was rescinded under the Clinton administration, put back under Bush, and it's gone back and forth over the last several presidents. And that is one of the characteristics of executive actions, is that any executive action taken by a previous executive is, remains in effect until an executive rescinds it. But that means when a new president comes in, that president has quite a lot of discretion to change any of the executive actions or policies of the previous administration.
So, you mentioned that these are not subject to the Administrative Procedure Act. So what is the relationship then between an executive order and a regulation that comes out of the executive branch through an agency that does follow the procedures in the Administrative Procedure Act? Does one of those supersede the other?
Yeah, that's a great question, Amanda. So, one thing to keep in mind is that you can't undo a regulation through an executive order. So if there has been a duly promulgated regulation that has gone through the full notice and comment period, a president can't just issue an executive order saying that regulation is invalidated because I don't like it, or for any other reason. What the president can do, however, is issue an executive order directing the agency that issued that regulation to revisit it. And so that's what you've seen, for example, in this administration, is the president issuing different types of executive actions, directing the heads of various agencies to review regulations that he doesn't like, and with an eye toward changing them. Of course, again, the president can't do something through an executive action that violates any existing law. So if there are regulations that implement a provision of law that was passed by Congress, the usual rules still apply, that the agency couldn't change that regulation in a way that violated the law. nor could the president do that through an executive action. But as I'm sure many of you know who work in this field, most laws provide agencies with a fair amount of discretion in terms of their regulations, and the president can certainly, through executive action, express his views about how the agency should exercise that discretion.
Thank you. And we've had a question come in from David wondering about court challenges to executive orders. And he gave as an example the Ninth Circuit decision on the immigration executive order from about a year ago now, which leads me to ask, so if we're thinking about challenging an executive order, what exactly is the cause of action? How do you frame a lawsuit like that?
There's a few ways you can go about it. I mean, certainly if it's an executive action where you think the president did not have authority to take that action himself, then you could sort of challenge it procedurally. I think most of the challenges to executive, there are some that have proceeded that way. And then there are the other bucket of challenges is really more to the substance, and that would proceed, using any of the causes of action that you would use to challenge a law or a regulation. So you would challenge the substance based on, whether it violated the Constitution or whether it conflicted with some other law, using whatever causes of action are ordinarily available to make those types of challenges.
Great. And David, if you wanted further information on court challenges, let us know. Let us hear your specific questions. So you just answered whether you can attack both the substance of the executive order as well as if there was authority to issue that executive order in the first place. So I'm thinking about our viewers, most of whom represent clients who have low income. How exactly might they come across an issue like this where they say, here's this executive order, it's harming my client? How might that come about for them?
Sure. I mean, I think there have been a number of executive orders that have had impact on low-income individuals and communities over the years, some good and some bad, right? I think, for example, one of the examples I talk about in the article is a sort of series of executive orders that really implemented non-discrimination in public housing. I think those are executive actions that have generally benefited our clients, and people have been able to use them to combat instances of discrimination in public housing on behalf of low-income clients. But under the current administration, we're seeing more executive actions that could threaten our clients. Certainly in the immigration area, that's been in the news a lot. I'm sure many of you have read about some of the actions and the court battles over some of the actions to place restrictions on both in terms of who can immigrate to the country and then what might happen to low income or just to immigrants in general once they're here. Another area that has, in my field, I work in health law, there have been a few executive actions about trying to undo pieces of the Affordable Care Act. And so we're seeing, limitations on who can get cost sharing or help buying health coverage under the Affordable Care Act as a result of some of these affordable care executive actions. And we're also seeing some executive actions that would allow new types of plans to enter the market and really market themselves to low-income individuals, even though they didn't offer the full scope of coverage and protections to which those individuals are entitled. So that's something that is coming down the pike now that we'll be watching very closely.
So let's say an attorney in a legal aid program or somewhere sees there's an executive order, they know it's going to harm the clients. What do they need to do? I mean, I'm assuming that if you have something like this with such a national scope, that it wouldn't make sense to have sort of piecemeal attacks on it across the country without some sort of coordinated effort. What would you recommend people do?
Absolutely. No, I think this is definitely, because of their scope, executive orders and executive actions are an area where a coordinated legal strategy is really important. And so I think if you become aware of some kind of executive action that is harming your client population or has the potential to harm your client population, it really would would be a good idea to connect with, the support centers, the legal support centers or national organizations that are working in that area to try to be a part of that coordinated effort. So, obviously, if you see something related to health, you could come to us. But if you're working in the immigration field, you could go to the National Immigration Law Center, housing, the National Housing Law Program, and so on. So I think that's probably the best way, and I'm sure that we would all be happy to work with local legal services programs and talk about how we can work together to challenge executive actions that are harming clients.
Thank you. And I'll remind viewers, we would like to hear from you. If this is the kind of thing you're seeing, or if you have questions about it, please let us know. You can send a question through live chat on YouTube or email me here at Amanda Moore, Moore, at povertylaw.org. I want to talk a little bit more about the law here and the framework of the law around the authority that a president has to issue an executive order. You go into this in detail in your article on the clearinghouse. Can you tell us a little bit about what that framework is?
Sure. So there's sort of three parts to the framework. The first question is whether the president has an express delegation of authority from Congress. And so where Congress has said, President, we want you to do X, that's a pretty clear case where the president has the authority to act, and any executive order or executive directive that's issued pursuant to such a directive from Congress would really just be reviewed for abuse of discretion. So that's a pretty deferential standard of review for those types of executive actions. But as you can imagine, there aren't a lot of instances like that. Congress doesn't usually give that type of directive to the president, so those tend to be pretty rare. I think the more common scenario is the second scenario, where Congress hasn't spoken either way. So Congress has not said, yes, President, we want you to do this, but also has not denied any authority. And there, the court is really just going to look at the executive directive, the substance of the executive directive, to see whether it's consistent with existing law, to make sure it doesn't violate the Constitution, and so on. The third area is where the president is acting in, defiance, in direct conflict with some type of congressional authority. And so there, it's sort of the opposite of the first scenario, where the presumption will be that that executive action is invalid, and the president has the burden of showing that either that Congress wasn't able to take away that authority from the president, or that it otherwise falls within the scope of his exclusive constitutional powers, and only then can that executive action be upheld.
Great. And the citations for all that, those are in your article. So if people want to know a little bit more or read the Supreme Court case that set that up, you can check out your article for those links. So David had asked about the Ninth Circuit case last year, which I think is maybe really fresh in all of our minds when we're thinking about executive orders these days. That refresh us on sort of how the legal arguments that were made there, not so much the substance, but just how people went about challenging that executive order.
Sure. So that case involved the so-called Muslim ban, and there were actually a series of cases in different courts around the country that challenged those executive orders. I think there were ultimately 2 or 3 executive orders, and also an a presidential memorandum that set out various iterations of the Muslim ban. And the main sort of substantive issue that came into the court was, whether the president had the authority to take this type of action through his executive power, and then whether the substance of the bans was discriminatory and violated the Constitution.
So it was both. Then it was, you didn't have the authority, and you did not. Legally, there was no. The substance is wrong. It's unconstitutional.
Exactly. So it really was, and I think many of the challenges that you'll see to executive actions contain both components. And strategically, as attorneys, that's sort of the way you want to go. You want to get at anything you can where you're making a challenge. So, and I believe that there were different rulings they're not all fresh in my mind, but that got at both sort of sides of the issue, both the authority as well as the discrimination, that the substance of the executive actions.
Got you. So tell us a little bit more about how you became interested in this topic. I was curious about that, how it intersects with your work at the National Health Law Program.
Sure. So one of the very first executive order that the current president put out was an executive order that ordered all of the executive branch agencies to do whatever they could to stop the implementation of the Affordable Care Act. The National Health Law Program, we've worked on implementing the Affordable Care Act, for going on 8 years now, and have with a particular focus on making sure that the law was implemented in a way that provided maximum benefit to low-income health consumers. So we were very concerned about the executive order that would try to roll many of the provisions back. And I was the person tasked with sort of looking at it and analyzing to see if it was valid. It ultimately turned out that that particular executive order didn't have a lot of effect. It basically ordered agencies to do whatever they could within the confines of existing law, which is a smart move because that makes it difficult to challenge that type of an executive action. But that also really limited the scope of what the executive order was doing. So it was more, I think, a way for the president to signal his policy goals and his policy agenda than an actual moving of that agenda forward. But that really signaled to us that this president was going to be using executive action to try to do as much with his policy agenda as he could. And so it was something that we started to look at a lot more closely and pay attention to about, what was the president doing? What was the scope of his authority? Should we be looking out for, knowing that the Affordable Care Act was sort of one of the items at the top of his hit list.
Thank you. And I'll remind our viewers to let us know our time is drawing to a close soon. So let us hear your questions on the live chat on YouTube or email me at Amanda Moore, Moore, at povertylaw.org. Abbi, what are some other recent executive orders, either that have been issued or there may be rumors of coming around that attorneys who represent clients in poverty may want to be on the lookout for?
Sure. So there have been a few in the healthcare arena, as I mentioned. Most recently, in October of last year, there was an executive order directing the Department of Labor to make it easier for association health plans to operate. And the Department of Labor followed up on that executive order with some proposed regulations that came out at the beginning of this year. Association health plans are basically a way for a lot of small employers to come together and buy group health insurance together as a large group plan, which allows them to be exempt from many of the consumer protections and requirements of the Affordable Care Act. So we have a lot of concerns that those types of plans will come in and, as I mentioned before, really market themselves to low-income populations and sell them basically junk insurance without people really understanding what they're getting. In other arenas, there have been, talk of different type of things that the president might try to do through executive orders. For example, trying to implement some of his agenda around housing and maybe rolling back some of the non-discrimination provisions I mentioned that have been implemented through executive order for public housing. Certainly, I think we'll see more executive actions around immigration. That's been a pretty big focus area for this president. And as the sort of back and forth with the court battles continues, I anticipate that we'll see more executive actions in that area as well. And then with public benefits more generally, I think right now it looks like the president is working with Congress to try to make cuts to some of the programs that our clients rely on. But I think it's reasonable to expect that if the president isn't able to get what he wants out of Congress, that he might turn back to executive actions to see what he could do there.
Well, thank you for that. And as you said, so if people see these coming out, a smart move would be to contact sort of the National Policy Center on that particular substantive area. Is that what you advised?
Absolutely, yeah.
Okay, great. Well, Abbi, do you have any final words of wisdom for our audience as they're looking into executive actions?
I think just, that this is not an area where poverty lawyers have really been focused traditionally, but I anticipate that it will continue to be an important area over the next few years for us to be paying attention to and thinking about how some of the president's unilateral actions can really impact our clients, and being prepared to take those on and challenge them when they really pose a harm to our clients. So I encourage people to just pay attention to this area a little bit more and understand what the limits of the president's authority are.
Well, thank you. Thank you for joining us today. Thanks to everyone for tuning in. I'll remind you that you can read Abbi's article. It's called Executive Directives, What Poverty Lawyers Need to Know. You can find it at povertylaw.org/clearinghouse. And as I mentioned, you can find all the citations and a lot more of the details of the article. If you enjoyed today's program, I invite you to join our mailing list at connect.povertylaw.org/clearinghouse. That way you'll always be notified when we have new articles and events such as today's Advocacy Exchange. And I'll remind you that the Advocacy Exchange is now available as a podcast. You can subscribe to the Advocacy Exchange on Apple Podcasts or wherever it is that you get your podcasts. And please join us for next month's Advocacy Exchange. I'll talk with Serena Holthe. She's special counsel for post-disposition issues at the National Juvenile Defender Center, and Sabrina Forte. She's a staff attorney at Bay Area Legal Aid's Youth Justice Project. We'll be talking about the collateral consequences of being involved with the juvenile justice system, and how when juvenile defenders and civil legal aid attorneys partner, they can better remove those barriers that come from the collateral consequences. That conversation will take place on Wednesday, April 11th, same time as today's program, 1 o'clock Eastern, 10 o'clock Pacific. And we hope that you will join us for that program. And until then, remember that you're not alone out there. Thank you.